Morning, everyone. My name is Eric Meyer, and I'm a consultant in the Dispute Resolution and Litigation Group of the Bangkok office of Tilleke Gibbins. And on behalf of our co-presenting firms, K&L Gates and Tilleke Gibbins, I would like to welcome you to our webinar on the current climate for investments in Southeast Asia. And with that, I would like to thank you once again for joining us on what we believe will be an interesting, informative, and very timely webinar focusing on concerns for investment structuring and disputes in Southeast Asia. And I say timely because when our two firms first started exploring the idea for this webinar, we were in the midst of the COVID pandemic. And in that context, we were considering looking at a couple of things. One, the risks to foreign investors that have been highlighted by the disruption caused by the pandemic, as individuals, businesses, and governments did their best to make some tough decisions as the pandemic spread. And second, the fallout from those risks, specifically in the form of the anticipated disputes and litigation, particularly investor-state arbitrations, arising out of that disruption and the decisions made by businesses and governments to deal with it. And then in more recent months, we've seen yet another example of risks and their after effects with Russia's invasion of Ukraine. The invasion and its aftermath obviously presented immediate risks for those doing business in Russia and forced many of them to make some difficult decisions in the face of severe measures taken by Russia to target some foreign investors. But it wasn't just those businesses. The effects of the invasion have been felt throughout the world across many industries at various points along supply chains. And so while foreign investment always involves some degree of risk, the events of the past 2 years have emphasized yet again the importance of being aware of and anticipating the risk, doing your best to protect against them, and what to do when all else fails and you find yourself in arbitration or some other type of dispute. And that's what today's program is about. In today's session, our presenters will begin by speaking about some of the types of risks that foreign investors should be aware of. They will then provide an overview of investment treaties and investor-state arbitration, and then look at the example of how some of these issues are playing out in the aftermath of Russia's invasion of Ukraine as an example. And they'll also look at ways to mitigate some of the political risks discussed in today's session. And finally, our speakers will give an overview of the other types of disputes in the current investment climate in Southeast Asia. And at this point, I would like to introduce that distinguished panel who will be leading us through these issues today. First is my colleague, John Frangos. John is a partner and director of Tilleke Gibbins Dispute Resolution and Litigation Group. Based in Bangkok, he works with clients from a wide variety of industries on complex cases across Southeast Asia. He's particularly active in leading the firm's aviation practice, as well as its compliance and investigations practice. And prior to his time in Thailand, John spent a number of years working in Vietnam. So this background has given him a strong knowledge of local business practices and customs. And he also has a deep understanding of the political and economic landscapes in Southeast Asia, which his clients greatly appreciate as he helps them navigate the legal environment in which businesses operate here. In addition to a Juris Doctor degree from New York Law School, John has a master's in international affairs from Columbia University. And our second speaker today is Rob Houston, a senior associate in the Singapore office of K&L Gates. Now, in his practice, Rob has acted both for and against sovereign states, state-owned entities, intergovernmental organizations, major corporates, and other clients in complex cross-border matters, with a key focus on public international law and investment treaty arbitration. And his recent work also includes the development, for the first time in investment treaty practice, of a model bilateral investment treaty incorporating investor obligations based on business and human rights principles. Rob has also done advisory work on state immunity, state responsibility, international humanitarian law, and political risk mitigation. Rob has a Juris Doctor from Georgetown Law in Washington, D.C., as well as a Master of Economic Law degree from Sciences Po Law School in Paris. And our third speaker today is Raja Bose. Raja is a partner also in the Singapore office of K&L Gates, where he leads their commercial disputes and international arbitration practice in Asia. He has more than 20 years of experience in international dispute resolution, having supervised, coordinated, or managed complex commercial disputes and provided strategic and structuring advice to clients across South Asia, Indochina, and Southeast Asia. Raja's extensive experience includes cross-border, multi-jurisdictional disputes in infrastructure, construction, shipping, marine insurance, oil and gas, international sale of goods, trade finance, and mortgage enforcement. He's also been involved in a number of high-profile investor-state disputes and investment treaty arbitrations. These included arbitrations in which he defended the governments of India and Bangladesh, as well as those in which he pursued actions on behalf of foreign investors against the governments of Thailand, Egypt, and Sri Lanka. Raja is qualified as an advocate and solicitor of the Supreme Court of Singapore and admitted as a solicitor of England and Wales. He's also featured on the panel of arbitrators of a number of arbitration institutions, including the Singapore International Arbitration Center, the Asian International Arbitration Center in Kuala Lumpur, the Indian Council of Arbitration, and the Hong Kong International Arbitration Center. And with that, I would like to turn it over to my colleague, John, who will begin by discussing some of the risks that foreign investors face in Southeast Asia.
Thank you very much, Eric. And thank you everyone for joining us today. So as Eric mentioned, I'll be discussing various types of what I'm terming government-related risks that foreign investors may face when doing business in Southeast Asia. And really, this doesn't apply just to Southeast Asia, but in countries around the world. Now, what I mean by government risks are risks which investors face due to an action or even an inaction by a host government that can affect an investment project or an investor and cause injury to that foreign investor. Now, these types of risks are different from the normal types of business risks that foreign investors may face from private sector parties like counterparties on contracts, because we're talking about governments. And because governments are involved here, there's a very political component to this, which can make these types of risks more difficult to predict, address, and resolve. And that's true, especially when you compare them to normal sort of commercial risks involving private sector parties. Also, we have to consider a host government often has a certain amount of leverage over a foreign investor. You know, when a foreign investor is doing business in a country, they don't usually want to be in a conflict with the host government. You know, it's bad for business. But sometimes disputes are inevitable, and this is what we'll be talking about today. And what's really important here is that investors certainly are aware of the risks, but to know that these risks can be mitigated through investor-state structuring, which my colleagues Robert and Raj will be discussing, and hopefully even securing some sort of governmental guarantees. So here you'll see a list of the risks that I'll be discussing. First is nationalization or expropriation. So what we mean here is when a host government seizes the assets of a foreign investor, seizes the investment project. And expropriation is when no compensation is paid for that. Next, we'll discuss government reversal on approvals for investment projects. This is a situation where a government may give a license, give an approval for investment project, and then subsequently cancel that approval, but not usually until a foreign investor may have expended significant resources towards that project. Third, we'll discuss when a government changes the terms of an investment project. So the parties may have agreed on a contract, and then later on, the government, for various reasons, decides to change the terms. Following that, we'll discuss discriminatory practices. And what this means is a situation where a host government discriminates against a foreign investor without any legal justification, and usually to the benefit of a local domestic investor. And then finally, we'll discuss arbitrary actions. This means an action by a host government against a foreign investor that has no basis in the law. Okay, so we'll start now to discuss expropriation. As I mentioned before, this is a situation where a government will nationalize, it will seize an investment project or assets belong to a foreign investor and not give any compensation. Governments do nationalize assets for various reasons, but where it becomes, I would argue, unlawful for the most part is when no compensation is given, and that's what expropriation means. Now, this practice goes back a long time. It's been happening for a good portion of the 20th century and continues today. The extractive industry, companies involved in extractive industries have been probably the most subject to this, oil and gas companies, energy companies, mineral and mining companies. And this usually happens when a host government wants to take control of the assets. And this can be for different reasons. It might be a situation where perhaps an investment project is making a lot of money and a host government decides that this revenue should belong to the state, not a foreign investor. So we're going to take control of the assets. It might be a situation where the host government, for one reason or another, is retaliating against a foreign investor, where for example, let's say there's a situation where the investment project is causing some sort of environmental problem, or there's a political backlash against it, and a host government says, well, we're going to retaliate against this investor by taking the project. It might be a situation where a host government will say to the foreign investor, you owe us a very high amount in back taxes and penalties and other things, and to compensate, we're going to seize the project. It could also involve a situation where a host government is in a conflict, a geopolitical conflict, with the investor's home country. And the investor is sort of caught in between this geopolitical matter. Russia right now is a good example with the invasion of Ukraine, where the United States and other countries have levied sanctions against Russia over the invasion of Ukraine. And as a way to retaliate against that, Russia has threatened to nationalize or expropriate investment projects located in Russia belonging to the foreign investors' home countries. Now, expropriation is most common, generally speaking, in countries with political unrest or political conflict like Russia that we just mentioned. So that should be considered. And like all these risks, they can be mitigated with investor-state treaty structuring, as well as ideally securing some sort of host government guarantee where the host government will guarantee to refrain from nationalizing or expropriating the assets. So I would like to give two examples of nationalization in Southeast Asia, starting with Myanmar. So in the early 1960s, there was a wave of nationalizations in Myanmar by the military government at the time, where the banking sector was essentially nationalized. The reason was a move towards socialism. And this really began decades of nationalizations in Myanmar. And then more recently, after the 2021 military coup in Myanmar, the government there again threatened to nationalize banks, because in that situation, banking staff, employees of the banks, walked off the job. They suspended work in protest of the coup, and the government there then retaliated by threatening to nationalize the banks. Another recent example involves Thailand, where a foreign investor alleged that the Thai government had indirectly expropriated a gold mine operated by the investor's local subsidiary. So in that case, the Thai government ordered the mine to be closed, and that for gold mining to be suspended by a certain time. And so the foreign investor in that case alleged that by the Thai government ordering the closure of the mine and ordering the suspension of work there, it was in a way a seizure of the investment project of the asset. And that case actually did go to investor state arbitration. So next, I'll be discussing here a situation where a government reverses itself on a project approval. So a government will approve an investment project. They'll give a license, they'll give an investment certificate, but then there might be a circumstance where the government decides to cancel that approval. And there's usually many reasons for this, and like all the risks that we're discussing here, because they involve government issues, politics often plays a strong part. For example, there might be a situation where there's a backlash against the investment project, whether by a country's population or a certain segment of the country's population, maybe an opposition party or others within the party in power, where they will decide we can't proceed with this project anymore, so we're going to cancel it. There might be a situation where a new government refuses to recognize an approval granted by a previous government. It might be where a new government says the previous government made a mistake in giving this approval, we're going to cancel it, or we're not going to recognize any approvals or licenses granted by the previous government because that government was illegitimate. So these types of risk here in terms of government reversal, very difficult to anticipate because it's political. It's very hard to know how a government will react. Broadly speaking, reversal on project approval is less common in countries that are politically stable, more common in countries that are politically unstable. Risks can be mitigated by investor state structuring, again, because you have the option of trying to take a host state to investor state arbitration, or ideally securing some sort of host government guarantee against the reversal, where there might be penalties or liquidated damages where the host government will pay a certain amount if they cancel the project. So three more examples, again, from Myanmar and Thailand. The example from Myanmar, and these are all real examples, by the way. A foreign investor received approval from the Myanmar government at the time to build a dam. They started construction. A few years later, the government suspended the project, canceled the approval because of environmental concerns and social impacts. In Thailand, again, this is the same mining project that I referenced earlier. There's a situation where the Thai government approved the project, there was a backlash, and then canceled it. And then another example in Thailand where a foreign investor received approval to build a railway project in Thailand. After the military coup in 2014, the new government wanted to cancel that project because for different reasons. One of the reasons it was signed by a previous government. They didn't recognize it. Here, we're talking about a situation where the government looks to change the project term. Of course, it's different from a reversal of the project approval. The government here is not canceling the project. They just want to change the term. We could look at it as if the government has a change of heart. Now, a government will look to either renegotiate the terms with a foreign investor, or there might be a situation where the government looks to unilaterally alter the term, essentially tell the investor, here are the new terms, take it or leave it. This could happen for many reasons. Political, again, for the most part. Maybe a government has a different priority from the time that it signed the contract. The government now wants to address its new priorities by changing the terms of the investment project. Maybe there's political pressure, an opposition party or people within the country. They said, this is a bad deal. Why did you sign it? You're wasting government resources. It might be a situation where, again, similar to the project approval, a new government disagrees with the deal made by a previous government, said they signed a bad deal, we're going to renegotiate this. Now, there may well be justifiable reasons for the change by government, but ultimately, an investor can find itself in a much worse position because an investor will have relied on the terms of a project. I would say that this is a fairly common risk, especially amongst the different risks we're talking about today. And I can cite a 2004 study by the World Bank, which showed that 15% to 30% of contracts covering $371 billion of private infrastructure investment in the 1990s were subject to government-initiated renegotiations or disputes. That's 15 to 30%. That's quite a high number. Now, this was in the 1990s, but still. And to show an example here, in Thailand, there was a project where a foreign investor had all the approvals to build a railway. When construction began, the Thai government decided that it needed to drastically change the plan for the project. Now, the Thai government very well may have had justifiable reason for the change, but still, the investor almost certainly found itself in a very difficult position. So next, we have discriminatory practices. And first, I should start by saying it's very common for host governments in where foreign investors are doing business to treat foreign investors differently from domestic investors. And this could be for a wide variety of reasons. Usually you have national security issues where there might be certain sensitive sectors that foreign investors are prohibited from investing in, like telecoms, for example, or energy. There might be political considerations where it's just not politically palatable to allow a foreign investor to invest in a certain sector. Just to give an example, in Thailand, for the most part, foreign investors cannot own land. Domestic investors, of course, can. However, what we're talking about here with discrimination, this is when a host government discriminates against a foreign investor and there's no legal justifiable reason. This discrimination is not based on the law. Now, this can occur either subtly through changing the laws to give a benefit or favoritism to a domestic investor. It might be where the host government changes the contracts to discriminate against a foreign investor, or perhaps even enforce the laws selectively. It might also be more direct, like the example that we'll talk about in a moment, where the government will just award a contract to a domestic investor, even though a foreign investor is more qualified. Risk here, of course, can also be mitigated by investor-state structuring or getting, ideally, a host government guarantee to treat foreign investors equally to domestic investors. The example I'd like to illustrate, again, in Myanmar, where after the 2021 military coup, a foreign investor sold its investment project. Both a foreign and domestic investor were interested to acquire the project. The Myanmar government refused to give the foreign investor approval and instead gave the approval to a military-linked company. The final risk is arbitrary actions. This is when a host government takes some sort of action against a foreign investor that is not based on the law. There's no legal ground for it. It's arbitrary. Like all the risks, again, maybe political considerations. Perhaps a government feels political pressure to take some sort of action against a foreign investor. And what I've seen also in my experience, it might just be monetary, where an investment project is making a lot of money, and the government wants that tax revenue, or they want the revenue, access to the revenue generated by the project. This is also very difficult to predict because there's no legal basis for the arbitrary action. So investors have to kind of navigate this area very carefully. To give an example, in Vietnam, where a foreign investor sold its project, sold its investment, it made a lot of money, from the proceeds of the sale. And then the Vietnamese government decided to impose a very big tax on the proceeds. The investor alleged that this tax isn't based on the law. This is wholly arbitrary. And this case actually became an investor-state arbitration matter. So to wrap up with some key points, I think what we've seen here is that these government-related risks are, for the most part, very difficult to predict because they involve politics, they involve government. You could look at a government's past history and conduct. That might be an indicator, but it's not a guarantee, right? So it's very tricky to predict these things. And of course, the action by a host government can have very significant negative consequences because many of the foreign investment projects that involve governments can be very significant, big projects. And so there could be a lot of losses for a foreign investor by an action by a host government. Now, throughout this talk, we discussed various mitigating factors, more from a legal perspective, such as getting government contractual guarantees or using investor state, which are certainly very important. What I'd also like to emphasize is that a foreign investor can employ commercial mitigating factors, such as keeping good relations with the government, not alienating the government, and showing the government how important the foreign investor's project is to the economy, that it's generating tax revenue, employing local workers. So these sort of commercial factors. But of course, a prudent investor should still keep in mind the legal mitigating factors and structure their investment with an eye to mitigate the risks using investor state structuring and securing government guarantees. Well, with that, that's the end of my presentation here, and I'll turn it over to Rob.
Well, first, let me say thank you very much to Eric and to John and also to Tilleke Gibbins. We really appreciate the opportunity to come and speak with you on such an important issue as this one. It affects so many people, especially in this region. And so it's really important and timely for today's discussion. So let's have a quick look at the current climate for investment concerns and investment structuring and disputes in Southeast Asia. Raja, did you want to take us off with a quick introductory overview?
Thank you, Rob. My name is, good morning, everybody. My name is Raja Bose. I'm Rob and my colleague Rob and myself speaking to you from Singapore. Just a quick cautionary note, and as I'm sure everybody would be aware, anything that we're speaking about today should not be considered as legal advice, and the presentation is limited in scope as appropriate for a general audience. Obviously, should you require any specific advice, our fellow panelists, Eric and John and Rob and myself will be more than happy to answer any questions or to attend calls in due course or answer your emails. That's all. Thank you, Rob. Back to you.
Excellent. So let's get underway. So we'll take a moment here. I'll speak with just a few words of introduction and then on investor state arbitration itself as a process. After that, Raja will speak in particular on Russia's invasion of Ukraine and political risk mitigation on some of the same topics that John has just given us an excellent overview of. So first, we've already been introduced, so just briefly, as my colleague Raja has mentioned, he and I are here based in Singapore. We do work in the investment treaty arbitration space. We also work in a number of related areas involving state-owned entities. The slides are here and you can have a look at those later. But as far as investor state arbitration is concerned, now this is a specific area of law, very kind of niche area of law, where there's an arbitration between a foreign investor and a host state. Now, the intention of this, why would governments agree or be interested in having the ability of, or having investors with the ability to bring claims against them? That's a question that a lot of folks will raise when we speak on these issues. And really, it's to promote and protect foreign investment. The idea in specifically in bilateral investment treaties, the idea is that one state will say to the other one, if your investors come and invest in our country, then we will protect their investments. And similarly, if our investors invest in your country, then you agree to protect them over there as well. So that's what the basis of investor-state arbitration is. As with all arbitration anywhere, it is consent. The host state will consent to submit those investment disputes to arbitration. So I just mentioned a moment ago treaties. So largely in the world today, international investment agreements, or IIAs, are the basis for investor-state arbitration. Now that's a catch-all term, IIA. And what it means is bilateral investment treaties. Now those are the kinds of treaties that I mentioned just a moment ago, where one state is dealing with another state on investment issues and putting in place a treaty that memorializes an understanding between the states, and sometimes often allows for investors from one state or the other to bring claims against the other counterparty state in the event that there is a breach of the treaty. So bilateral investment treaties, a lot of folks will call those BITs. Treaties with investment provisions, that's another kind of catch-all term, TIPS, and it does include free trade agreements, in particular investment chapters of free trade agreements that often do allow also for investor-state arbitration. That's not all, though. There are also sometimes contracts that are agreed between investors, particularly, John mentioned in the energy sector, particularly major investors that are coming in, taking a big risk in investing in a particular jurisdiction. And they want the assurances to the extent they can that it may be commercial risk that's normal and expected to be undertaken, but maybe limiting some of that political risk that's been mentioned earlier today. And so what they'll do sometimes is they will agree with a particular state agency or ministry to have a contract in place that will allow for some sort of recourse to investor-state arbitration, not based on a treaty, but based on the contract. We'll focus today, though, in this discussion on the kind of investor-state arbitration that arises from treaties like the bilateral investment treaties. So taking a step back, there's a global investment treaty landscape at play in the world today. Now you can look at the UN Convention on Trade and Development's website, and you can see an updated running total of the bilateral investment treaties that exist. 2,231 is what it sits at today, presently. Also TIPS 335. And so right now, more or less 2,500 different agreements signed between states around the world today that would allow for investors potentially, depending on the terms of the specific treaty, a specific IA, will allow investors to proceed with claims in investor-state arbitration, or will offer some other protections or promotions for foreign investment. So let's look at one. Here is an example with a definition of the term investor. So who is an investor? Here's an example from Article 1.1 of the Turkey-Thailand BIT from 2005. And so here, as you can see, the term investor, it includes natural persons, okay? It also includes juridical persons. So companies, corporations, business associations, as long as they're constituted or otherwise duly organized under the law of the party and have their seat together with their real economic activities in the territory of that same party. Sometimes treaties will be even more general than this. Sometimes it's enough just to be incorporated in a particular jurisdiction, and then you're a foreign investor if you're a juridical entity. Sometimes, as here, then you might have to check other boxes too. So it's not just enough here under 1B to be incorporated in the right jurisdiction, but you also have to have your real economic activities in that territory. It's important to look at the terms of the treaty, and that'll be a theme, I think, that we return to over and over and over again. You have to look at a particular investment situation, context. You have to look at the specific treaty that might apply to understand, do you have coverage? Is there a treaty in place that's going to help you in the event that a political risk mitigation event arises? And otherwise, you might lose your investment. It's important to understand if you're a covered investor. That's the bottom line for this slide. And so in the treaties like this one here between Turkey and Thailand, then we look to the terms of the treaty to understand who's a covered investor and who's not. So moving on here, you also need to understand, of course, if your particular investment is a covered investment for the purposes of treaty protection. And so here we're looking at another example, Cambodia-Vietnam BIT from 2001. And we can see a definition here of investment that is also very broad. The term investment shall mean any kind of asset invested by nationals of one contracting party in the territory of the other, and admitted in conformity with the laws and regulations of the letter, including but not exclusively, and then there's a list. So the next slide has a list, but it's not listing everything that could be a possible covered investment. Covered investment means any kind of asset, right? And so these are really broad terms. Most of the bilateral investment treaties that are in force around the world today have these kinds of really broad terms that will cast a broader net around most of the investments in the world today. I think it's fair to say that you could think of assets in a number of different ways. So let's look how this treaty does. Movable, immovable property, other rights, mortgages, privileges, guarantees, shares, bonds, rights derived from them, or any form of interest in companies in the territory of the contracting party, claims derived from shares, bonds, or any performance having a financial value, intellectual property rights, technical processes, goodwill, know-how, business concessions having an economic value conferred by law, okay? A wide range of investments across sectors, not just the energy sector, the extractives industry, but across all sectors. You could have cases arising in the transportation sector. And in fact, there are a lot of cases that have arisen in the transportation and telecommunications sectors. It just has to be an investment that's covered by the terms of the treaty. And so, broadly speaking, most of the bilateral investment treaties that, especially those that were signed back in the 1990s and the early 2000s, they're going to have that broad ambit that will cover most of the investments across sectors and regardless of the kind of nature of the investment. Obviously, also always with the caveat that you need to look at the specific terms of the treaty. More recently, there's been, the states have taken a second look at some of the treaty language and decided to be a little more detailed in what constitutes a covered investment. So there will always be a context within which you need to understand the coverage of the treaty. But by and large, this is generally the broader practice as it has extended over the last few decades. Substantive protections. Now here's the question, so what? I'm a covered investor, I have a covered investment, but what do I do now and so what? Well, the treaty, the purpose of the treaty from the investor standpoint is to provide additional protection and maybe to give you a little more ease in making your investment with certain specific substantive protections. Once again, every treaty is different, but that doesn't mean that treaties don't, from one to the next, have some similar types of substantive protections, and they certainly do. In fact, the same language will appear in one treaty as in the next and the next and the next. And so you have some substantive protections, including the following here. The two that are most commonly invoked in investor-state arbitration are fair and equitable treatment, and then unlawful expropriation. So fair and equitable treatment is a term that has traditionally not been defined in a treaty. That's important. That's important. Because if you don't have the term fair defined in a treaty, if the treaty just says something like an investor must be given fair and equitable treatment, well, gosh, then it's left up to the tribunal to decide what's fair. And so you have fair and equitable treatment, not surprisingly, featuring as the one claim that is most often brought, the one substantial protection that is most often cited in claims. Okay, because investors say, well, look, this was my investment. This is what happened when the government put in a certain government measure, a certain economic measure. And then as a result, this is the impact that it had on me. I don't think that's fair. And then they can proceed, provided that it's a covered investor with a covered investment and other things line up under the treaties, they can proceed in investor-state arbitration to bring that claim and have it heard by a tribunal. Unlawful expropriation. Now, this is an area of law in which as has been mentioned earlier, in which an investment may be wholly or sometimes partially taken by the government. Largely, it's where it's a whole, as has been mentioned in the case of nationalization, a whole taking of an investment. Older cases has been the case where the Army has rolled up and said, this is now our property. When something happens where you think that whether by law, in an indirect kind of context, or even directly with direct actions of government actors, where it's been taken, then you might think, well, gosh, that looks like an expropriation. And those are the cases in which you might explore investor-state arbitration. Now, there are other protections. Fair and equitable treatment and unlawful expropriation are the two primary ones, but there's also full protection and security. And you can largely think of this as for lease protection. The government doesn't necessarily have a high bar to provide full protection and security, but there is a minimum expectation for how governments are to provide certain levels of protection for investments. Most favored nation clauses will allow for the requirement on a government to give the same kind of treatment, the same level of protection as it gives to other investors in a third country. National treatment, that's the same kind of idea, but where we're talking about domestic investors. So if it's a situation in which investors will look to the treaty to say, well, government X, you're supposed to, because you've promised in the treaty to do so, you're supposed to provide me the same kind of level of protection that you do for your own domestic citizens for their investments. So umbrella clauses, that's another very interesting area of investment treaty practice, where you have a broad obligation on states. These can be the sorts of obligations in which a state has agreed not just to follow the rules under a specific treaty and to provide certain specific protections, but sometimes states agree to provide investment treaty guarantees for all obligations they've undertaken. And sometimes those have been understood also to include contractual arrangements that have been undertaken by those governments. And so you might even have an investment contract that provides for commercial arbitration on one side, and yet, provided that the government has taken action under that contract and that is therefore the actions are attributable to the government, we'll talk about that in a moment. In the end, you might look to that and say, well gosh, that's a breach of an obligation that you took on. And depending on the language of the treaty, there might also be parallel protection under the treaty for that obligation. And then, of course, free transfer of funds related to investment has been for a long time one protected area. There are others as well, but these are the main substantive protections that you'll often see in investment treaty practice, particularly fair and equitable treatment and unlawful expropriation. So taking just one quick look at compensation for loss. This is from the Article 4 of the Russian Federation United Kingdom bid, and we just mentioned this in brief, that in fact there are also provisions in the investment treaties in the event of war, or as it says here, state of national emergency or civil disturbance. Access to arbitration looks like this in investment treaty arbitration. It's provided here at Article 8.3, where the dispute between an investor and a host state is referred to international arbitration. An investor concerned can have the right to refer to the dispute either to here, the Stockholm Chamber of Commerce, or under the UNCITRAL rules, the UN Commission on International Trade Law. So limitations on claims exist. We don't want to convey the impression that investor-state arbitration is easy and always available. It's not. There are limitations, sometimes jurisdictional, sometimes of an admissibility kind of nature. There are also, you can look at limitations as being based on the time in which a claim is brought. If you wait too long, sometimes you can't avail yourself of investment treaty protection. Certain investors will have the ability to bring the claims, and certain others may not, depending on the language of the treaty. Okay. Certain subject matters may not be subject to dispute in investment treaty arbitration. All of these things will be, once again, specific to the terms of the treaty that you want to cite as the basis for your claim. There are also state defenses, and we won't go too far into that, but we'll just mention briefly some of the state defenses that are listed here. Force majeure, distress. States have the ability, as a matter of international law, customary international law, to say, look, there may have been what would otherwise be a breach of my treaty obligations, but this is the defense. And that's another area in which the investment treaty arbitration practice, it's important to understand in practice what sorts of defenses may be available and whether you may have a case in the current context, the specific context. Finally, looking at straight attribution, how do you know when the state actually did something or did not? What if it's a state-owned entity? Okay, there are specific rules in customary international law on when you attribute an action or inaction to the state and when you can't. Okay, and so if it's attributable to the state, well, that means something. We'll just take a quick look at this. This is Article 2 from the draft articles, the ILC's, International Law Commission's draft articles of responsibility of states for internationally wrongful acts. Now, this document has been found by myriad tribunals and academics and courts to represent the current state of customary international law. And so when you look at it, you can understand that unless it's displaced by treaty, this is the rule that generally applies. You can see that there's an internationally wrongful act of a state where you have two things. It's attributable to the state the act, and also where it constitutes a breach of an international obligation, like the ones that we've been talking about under the treaties. So that's what state attribution looks like. And it's once again important to look at the specific context and to understand whether the current context can give rise to a claim in investor-state arbitration or not. So let me pause there and pass it over to Raja.
Thank you very much, Robert. Before I speak to my slides, I thought there were three things that I wanted to mention. The first is that whilst the overview of the topic that Rob covered may come across as very technical and complicated, the reason is that it is. But the good news is that that is not your problem. That is either our problem or his problem to figure out. In fact, Robert loves investment treaty arbitration so much, he reads investment treaties at night to his children. And he's got 3,500 of them to get through. He's gone through about half. But the point I'm trying to make is what we are hoping that today's webinar will equip you with is the questions to ask and some of the preliminary answers to those questions, which will hopefully show you that there may be options you hadn't previously considered. So that's the first point. Don't worry, don't let the technicality of the subject matter either scare or bore you. The second preliminary point I wanted to make is we should perhaps have said at the beginning that most of the time when you have contracted with in a foreign country and you've got an investment, and we've already explained it could be any kind of contracting relationship with an entity in a foreign country, you are focused very much on the terms of your contract, your agreement, the performance bonds, the side letters, the guarantees, the letters of credit. And that is correct. What we are talking about here is outside this body of commercial agreements, there is a separate and parallel set of rights and obligations that exist that had nothing to do with you. You did nothing as an investor to create that. That was your government. And here I'm talking about either the government of Thailand, and we will look at the number of investment treaties that Thailand has signed, assuming you are based in Thailand, or from any country where you have a presence, or your subsidiary that you contracted through has a presence. And for example, let's say you're a Thai company in the business of exporting rice, just as an example. You have a subsidiary in Vietnam, which is another rice exporting association, and your Vietnamese subsidiary contracted is a shareholder in a joint venture with a Russian company. Just as an example, it could be any country in the world. That set of arrangements, how you structure your investments, can give rise to this parallel set of obligations because the government of Thailand, the government of Vietnam, the government of Russia have entered into a series of agreements, and these are called treaties. They're a government-to-government agreement, but they give you, a private entity, a right, which is unusual. Most government-to-government contracts relate to a government-to-government obligation, and we're not talking about that. These are obligations and rights that they have created that give you the right to pursue an action. And why is this important? This is important because at the commercial contract level, and John will speak to a little bit about this level, you invariably, many foreign investments have to be structured through a company that you incorporate in the destination country. And that company may be subject to court injunctions, actions taken domestically by the government or other regulatory agencies that make it very difficult for that company to move forward with its claims commercially. The shareholders of that company have a parallel set of rights, may have, under investment treaty. And that's why this has relevance, because it creates a different avenue of recourse, which may not be available to you. There may be commercial defenses under your commercial contract that your counterparty can raise. There may be a limitation of liability. None of those per se are going to affect your claim under investment treaty. So that's why it's important to look at whether such options exist. I'd also say at the beginning, what if my country that I have contracted through, which I've got, does not have an investment treaty? Does that mean all this is a waste of time for me? And we'll explain at the end of our topic and during the Q&A why that's actually not the case, and why you still should have a look. So with those introductory remarks, sorry, I had a third one. And my third and final introductory remark is this. Whilst I am talking about Russia and Ukraine, and in some ways the pandemic, what we have to say has a much broader application. I'm simply talking about Russia and Ukraine and in passing about the pandemic, because at least in my lifetime, and I've been practicing law now for, this is my 30th year, the pandemic and the Russian invasion of Ukraine are unprecedented. I have never seen anything quite like either of these in my lifetime. I hope I never will see anything more like it. But unfortunately, I think the longer term impacts of both the pandemic and its impact across the world, and what is happening now in Russia and Ukraine and its broader impact, the lingering effects are going to impact all of us. So we talk about them because they are topical, they are current, but the message and the information we are trying to convey to you applies to any foreign investment anywhere in the world at any time. Okay, next slide, please. It goes without saying that since the beginning of 2021 and over the last year now, the situation between Russia and Ukraine has deteriorated to the point where we are literally at war. The two countries and their surrounding neighbors are impacted. We've, on the slide, you'll see a timeline that we've taken from both Reuters and BBC that take you at least up to June 2022. And the important point there to know is we know there was an invasion by Russian forces in Ukraine. The impact for those of us who are not directly affected is that the long-term impact of this invasion is going to last for years. I don't think it could last for years. It will last for years. We can already see that. Next slide, please. Apart from its humanitarian, the crises that's created and the terrible loss of lives and damage to property, we are going to be lawyers, and we're going to focus today on the economic impact, and in particular its impact on investors. And we've got a selection of headlines here, one from the Financial Times, 4th of March of this year, saying investors face deep losses on $170 billion of Russian assets. Next slide, please. From Al Jazeera, and we'll come back to this point in a second. What are these lists of unfriendly countries amidst the Ukraine crisis? This was from March of this year. Next slide, please. And finally, from the Financial Times on the 8th of May of this year, that Ukraine war cuts foreign investors off their Russian assets. You may have heard, I think there was a Reuters article from earlier this year concerning the French automaker Renault, and they took a very difficult decision. They have 45,000 employees in their Moscow manufacturing plant. They've made the difficult decision to effectively divest or transfer their ownership and assets to the Russian government for consideration of 1 ruble for a period of 6 years in an effort to protect their employee jobs and to hopefully preserve their ability to come back to Russia in 6 years' time. And they're not the only one. McDonald's, which again has thousands of outlets in Russia, has transferred over their entire business to a local operator. And all of these are being done amidst, for a variety of reasons, pressures brought by their own companies, their own governments, humanitarian issues, people's sense of justice and fairness. Next slide, please. Now, as somebody who is, as an investor who's sitting outside Russia, and we've written a couple of articles that are headlined stuck between a rock and a hard place. And that really is the plight that a foreign investor face. Quite aside from external sanctions that are being imposed by the governments of the US the EU and the UK, amongst others, including governments in Singapore, that are overlapping, that have different scopes of coverage. An investor is also faced with actions that the Russian government has taken domestically, often in retaliation against the perceived unfairness of external sanctions, or in their minds and from their view to protect the Russian economy, the Russian employees, Russian and the functioning, the day-to-day life in Russia. And these, I've just listed the headlines here on some recent steps that the Russian government has taken. So for example, there are temporary restrictions on Russian residents, providing foreign currency loans to non-residents, crediting foreign currency into bank accounts outside Russia, conducting money transfers using electronic instruments of payment. So if you're a Russian counterparty, there's a good chance they're not going to be able to pay you, regardless of the way you had structured your payments. You require additional transactional approvals. You need the Russian government clearance, certainly where the contracting counterparty has been deemed to be an unfriendly foreign state. There's a prohibition on the export of cash. There are restrictions on debt payment, fulfillment of loan obligations. There's a prohibition on exports or imports into Russia of certain products and raw materials. There's also a significant change in the law relating to the non-enforcement of intellectual property rights. Even more worrying than these, which have been quite specific, there's been discussion in the press and statements by, particularly in the Russian press, that the Russian lawmakers have proposed to transfer businesses or foreign companies that are leaving Russia, giving the owners of those firms the option to either resume your operations or to sell their businesses within 3 months. And this is essentially expropriation sanctioned at the state level against foreign businesses, and most likely it is not non-discriminatory. It is targeted specifically at countries that the Russian government has deemed unfriendly. Next slide, please. Political risk. I think there's much that a company can do to manage and structure and hedge against commercial risks. Political risks, as John alluded to when he started, are difficult to identify, they're difficult to predict, and they are equally difficult to hedge or manage. The one point I was going to tell John about the unpredictability of political risks is what you can predict and you should predict is that there will be a problem. There will be a problem. It may be a minor problem. It may be a manageable problem, but a long-term investment that is going to, that has as its duration a number of years. We're not talking about one-off commercial transactions. We're talking about investments where you are in a relationship of some form with a foreign government, an entity, a ministry, a governmental department, or are impacted by the local laws of a country over a duration of time. And with the possible exception of the country that I'm sitting in, across Asia, you can see that we live in a fairly volatile political environment. You know, there's true democracy in most of Asia, and that means people have a right to change governments, and they frequently do. And it's often, in my experience, the change in government that brings tension to a lot of these long-term foreign investment projects. The slide that you will see is one that we prepared for one of the articles that we've written. These are countries that Russia has a bilateral investment treaty with. Of concern are the countries shaded in gray. These are countries that Russia has designated as an unfriendly country. And these are investors from these countries who have some sort of investment in Russia, we would think and we would assume particularly at risk at having their assets seized or expropriated or being subjected to some form of arbitrary or discriminatory treatment by the actions taken domestically by Russia against their investments. Next slide. Sorry. Given that many of you are dialing in from Thailand, it is noteworthy, and you would have noted from this list, that Thailand does not have a bilateral investment treaty with Russia. At that point, let me answer the question in the room. Does that mean if you're a Thai investor, the last 1 hour has been a complete waste of your time? No, it hasn't. It hasn't because A, you now know that investment treaties exist. You now know that were you to make an investment going forward, depending on the country in question, it is worth considering structuring your investment through a country that does have an investment treaty in. So for example, back to my question here, I'm a Thai rice exporter. I want to do business in Russia. I structure my investment through my subsidiary in Vietnam. You will notice that Vietnam does have an investment treaty with Russia. And it could be my Vietnamese company that is a shareholder in a joint venture that I enter into Russia. That Vietnamese shareholder would have a right of recourse against Russia. And again, as I said, we're talking about Russia today. This could be a contract that you're entering into with India. It could be an arrangement that you're doing with Singapore or Malaysia or Croatia or Turkey. The points that I'm trying to make is they apply to any foreign investment anywhere in the world. There are steps that you can take to give yourself an added layer of protection. And it may bring the pricing and cost down on loans that you may need to get because you have an added layer of recourse that is almost isolated from the type of domestic political pressure that a foreign investment is typically subject to. Next slide, please. The scope of substantive protection is based on text. Rob kind of repeated this line almost ad nauseum. Everything turns, we've been speaking in very general terms, whether your particular investment can receive the type of protection that you need in this factor, it all comes down to the wording of the treaty, but that's our problem, right? We will be able to help you through that. Again, shareholding is probably the most important thing for you as a potential investor to realize that it's where how you structure the shareholding of your investment operating vehicle in the domestic country, and it's not just the immediate shareholders of that company, it's their shareholders and their shareholders. In fact, Rob and I are dealing with a case now where we are bringing an investment treaty claim on behalf of a shareholder that is 4 layers removed from the shareholding of the domestic company. It goes through 3-4 different countries, and it is that final countries, the investors from this 4th country that are pursuing a claim because their indirect shareholding in the operating company is the one that's been expropriated. And at the risk of stating obvious, this means that one needs to undertake a careful review of the available investment. Next slide, please. Key considerations, look beyond the limits of the contract. As I said, there's a parallel level of protections. Structuring is important. That's where we work quite closely with our transactional and corporate colleagues when investors come to us and say we're considering making a fairly substantial investment or entering into an investment agreement with a foreign entity. How should we go about doing this? And important to consider a variety of risks, commercial risks, tax, whether you should use a joint venture, whether you should go through a licensing scheme, and to take a macro view of the situation, all of which are fairly obvious. Next slide, please. If an investment is expropriated, recourse under investment arbitration may be the only remedy. Corporate structuring by reference to investment protection is a key component of political risk, and it's an uncertain time. I think these are fairly self-explanatory points. And I believe that's my last slide, Rob. Key considerations. Before any dispute arises, are my investments well structured? So I think what I would ask you to do as people who are attending and to those of you advising your clients is what we have to say applies to existing situations you're in. It applies to potential situations, potential transactions you might be entering into, as well as looking back on situations you find yourself in to see, could I have avoided that, or would I have been in a better negotiating position if I'd done some structuring? So structuring is key, right? It's better to avoid a situation than to fix a problem. And And obviously, the mere fact that you have a claim doesn't mean that you need to pursue it, that you should pursue it, because these tend to be fairly expensive actions to pursue. But we've found that with many governments who we work either for or against, most people are in agreement that avoiding a dispute is better. And where a government knows that the consequences of not listening to you or not being commercial or not compromising is that you may file a claim, that often leads to at least a more constructive settlement discussion. I think that's all. I'm not going to touch upon third-party litigation funding other than to say that if financial constraints are preventing you from pursuing your rights, there's a fast-growing industry in you can now essentially get a funding, a loan, of a non-recourse loan to fund such actions, and investors are particularly active in the investor state space. Thank you very much. I will hand back over to John, and very happy to answer any questions that you may have at the end of the session. Thank you.
In my portion of the webinar, I'll be discussing disputes in the current investment environment in Southeast Asia. So more local related disputes. Now, I think as everyone on this webinar likely knows, mainland Southeast Asia is a prime destination for foreign investment, both from Northeast Asia, from Europe, from the US, but also within ASEAN itself. Now, I'm focusing on these countries, Thailand, Vietnam, Cambodia, Laos, Myanmar, because these are the countries where I work. So this will be the focus of my talk now. As we can see from the numbers here, during the COVID years, foreign investment is still fairly strong, especially in Vietnam. And over the long term, I think we all can agree that foreign investment will likely grow, at least for a number of the countries here. And almost every sector is expected to grow. But of course, with all of this investment, disputes will inevitably follow. And as there's more business activity, there's more likely to be disputes. The nature of these disputes I'll describe as cross-border in the sense where you have an investor sitting in one country doing business in another country, and then gets into a legal dispute, whether with the government or with another private sector party in that host country. So we have cross-border disputes. In terms of the current investment environment, what I'm seeing, and by the way, the talk that I'm giving now is all subjective. This is based on my own experience and observations and views. Right now, defaults, plain vanilla contract defaults are the most common. This is largely as a result of COVID, as well as the increasing economic difficulties that the world and Southeast Asia are seeing. However, I also anticipate an uptick in various other types of disputes. And just a number of them listed here: construction and infrastructure disputes, employment disputes, which, as anyone who works in the jurisdictions I mentioned before will know, these are big issues. Also aggressive regulatory enforcement, as well as cybercrime and white-collar crime. And I'll talk about all of this. Okay, so first a word about defaults, with the defaults that we're seeing in Thailand and elsewhere in our jurisdiction. So the economic consequences of COVID have been felt in many different sectors. In manufacturing, we're seeing manufacturers not being able to meet customers' demands. We're seeing other suppliers breaching their own agreements with manufacturers. In aviation, where I work quite a bit, we're seeing airlines breaching aircraft lease agreements. Property and hospitality, there have been, of course, tourism has been very negatively affected. And so we're seeing disputes in that area. We're seeing loan agreements with banks and other lenders being breached. And all of these defaults, I would say, are having a ripple effect, resulting in even more defaults in other areas. For example, shareholder disputes, where we see joint venture partners, whether it's a foreign investor and then a local investor, or even two local investors getting involved in their own shareholder disputes that result from, say, a default on a loan agreement, M&A related disputes. Also, an uptick in bankruptcy and restructuring matters, court supervised restructuring. For example, Thailand, to my knowledge, has had at least 4 airlines file for business rehabilitation in the Thai bankruptcy court. So as more companies face defaults and have creditors chasing them, they're seeking bankruptcy protection. Now, just a word about what to do in this situation. And this is really from a creditor perspective. So you have a party that has defaulted on a contract. What do? You have to enforce against that defaulting party, to enforce the contract. In the jurisdictions that we're talking about here, it's Thailand, Vietnam, Myanmar, Cambodia, Laos. Local litigation will usually be required. Foreign court judgments, for the most part, are not enforceable. This means you have to go to a local court. It also means that, for the most part, a debtor may not have assets outside of the home country, so you have to go to a local court. So you heard me before talk about cross-border litigation. Well, that's really a term of art, because the litigation is ultimately local. You might have a party sitting in another country, but the litigation is within a local court. Another point to consider here in these jurisdictions is that it's very challenging to freeze assets for different reasons, which I won't get into now, but the result is judgment enforcement may be very challenging, because you'll have a debtor who may not have any assets or even transferred assets before judgment can be enforced. So these are all considerations. Now, I also want to mention that arbitration is certainly a very viable option. And by arbitration, we can consider both investor-state arbitration as well as regular commercial arbitration. Because all the countries listed here, they're members of the New York Convention, and that means that foreign arbitral awards are enforceable in those jurisdictions. So a creditor or a party to a contract, they can go to arbitration in, say, Singapore, get an arbitral award, and then seek to enforce it. Now, of course, arbitration, very beneficial, especially if a debtor might have assets outside of their home jurisdiction. So you can go around the world to enforce that arbitral award. In addition to Singapore, a creditor, an investor, they can also look to local arbitration institutions. But the point I would like to emphasize here is that even if you have the arbitral award, you will ultimately have to go to a local court to enforce that award. So you can't escape the local court system for the most part in a case. Now here, I'm going to briefly talk about some types of anticipated disputes, the matters I mentioned at the outset. And again, these are just my subjective views based on my experience and observations. So first, construction and infrastructure disputes, because what we're seeing, certainly in Thailand and elsewhere in our region, there's such a strong demand for infrastructure, huge demand. And the governments here have been helping to build infrastructure to, of course, meet that demand, but also to help revitalize COVID-hit economies. You know, the economies have been really hurt over the last few years. And in order to help bring economies back up, stimulus spending by the governments, a very Keynesian approach, very demand side approach. Now, of course, what I believe is that as more projects get underway and there's more construction infrastructure projects, that will inevitably lead to more disputes. Also, as inflation now starts to bite more, we see the cost of material and labor increasing. The terms of contracts may have to be changed, and that will also likely lead to a higher chance of disputes. Next, employment disputes. And again, because of inflation, workers are demanding higher wages to keep pace with higher costs of energy and food. Also, economic difficulties brought both by COVID and as well as the current overall economic condition globally in Southeast Asia means more layoffs. And we're seeing much more management and employee friction than we have in the last few years. And this is all culminating not just with disputes with workers individually, but disputes with labor unions. And as most people know that work in Thailand or Vietnam, workers will file lawsuits against their employers for employment-related matters. An additional issue will be aggressive regulatory enforcement. And what I mean by this is a situation where governments, they've spent a lot of money trying to revitalize the economy, stimulus spending, like we're talking about before with construction and infrastructure and a host of other measures. So government coffers have really been depleted. So this will likely result in tax officials, customs officials, other regulators taking a very aggressive posture to levy penalties and fines and whatnot to get money back into government coffers. Also, political pressures. Governments want to be seen as active. They want to be doing something in this environment. And then finally, cybercrime and white collar crime. During COVID and really preceding it, we've seen a very significant increase in online commerce as more people get online in Southeast Asia and more businesses done online. And of course, that will likely lead to more instances of cybercrime. And we're seeing that certainly in Thailand. In addition, as economic times get tougher, through COVID, we saw it, and I think it's going to continue. More employees, as well as companies, bend the rules to commit embezzlement and other forms of economic crime, white collar crime. So companies and investors will have to deal with this as well. So just to close my remarks here about the current state of litigation that we're seeing, and this certainly applies to Thailand. After a very long time during the COVID years, courts are now hearing cases again. Unlike courts in other jurisdictions, the courts in Thailand and elsewhere have postponed hearings. They did not go to virtual hearings, but now cases are starting again. So that's certainly a positive thing for people involved in disputes, certainly for the lawyers, I guess, right? The borders are also generally open. So when we're talking about international cross-border disputes, witnesses now can attend local hearings, whereas before they couldn't. The result of all this, though, is a tremendous backlog in commercial cases, certainly the case in Thailand, where, we're seeing trial dates on cases being scheduled for late 2023. So that has to be considered as well when deciding to initiate a lawsuit. Well, thank you very much. That's all I have for this talk, and we look forward to any questions we have. So I'll turn it over to Eric to help moderate the Q&A.
Thank you, John, and Rob and Raja. Thank you both again for your presentations as well. And I do see that we have a couple of questions already from the audience, and I'll start with the second one. And I guess this would be for Rob or Raja, which is, do you have a sense of the number of IIT claims that are currently being pursued against Russia? And how do these numbers compare to pre-Ukraine invasion totals? Do either of you have any thoughts on that? And I guess a subsequent question to that would be, do you think it's going to ramp up soon, and if so, when?
Rob, you're on mute.
Thanks. So the UN Conference on Trade and Development has a portal online where they report these kinds of statistics when they become publicly available. So there are 10 that have been reported where the home state of the investor bringing the claim is Ukraine since 2014. And so that is a dramatic increase. And you can see that some of those cases, or in large part, the wave of those cases is in relation to the situation in Crimea. And so here we're witnessing a dramatic expansion of the same kind of thing, where there will be many, many claims more, and then who knows what the number will be, but there will be a significant increase. There will be another wave. So basically the answer is how many cases right now? About 10 that are publicly known from 2014 to now, where Ukraine is the home state of the investor. Okay, it says on that website also that 7 of them are pending, 3 of them have been decided in favor of investors to this point. Okay.
What I would add to that is in speaking with our counterparties from other firms, particularly those in other parts of Europe who are closer to what's going on. Many are in the process, from what we've heard, are preparing claims. There's difficulties at the moment with getting evidence from the ground, given the current situation there. Documents and papers, many have been destroyed. Witnesses are not immediately available. And so there's just general disarray, but they are in the midst of preparing to file. So the other thing that will impact how many claims are filed under investment treaties, or may rather, is that there's also a lot of discussion about some sort of compensation fund probably being constituted at some point in time in the future. I think people see difficulties. The parallels have been drawn to the Iraqi invasion of Kuwait and the compensation fund that was set up by the UN. But here, any such move was likely to be vetoed by both Russia and China. So I don't think the UN is going to be the body to do that. But something along those lines may be set up using Russian assets that have been seized. So that's also going to impact the likely avenues for recourse.
Please.
Yeah, I was going to move on and try and tackle the first question.
Okay, let me just say briefly, one thing that's important for folks to remember and to recognize is that these things don't get filed right overnight. Okay, a lot of the treaties will allow for a period of time within which to bring the treaty. Sometimes it may be 5, or the claim, sometimes it may be 5 years. Sometimes even if the treaty is terminated, the treaty may have provided for a sunset clause that allows for treaties to be brought claims to be brought even after the treaty itself is terminated. So there's a longer build-up time for the filing of these cases. But just coming back, the total it shows is 27 cases, 10 of those since 2014 with Ukraine-based investors. There's definitely an increase. And I
think the other point to make on that is there's almost invariably what is termed a cooling off period. So some prior notification that needs to be given to the host government, usually put in an effort to get the parties to start talking along settlement lines. And it invariably provides for 6 months. That's quite a common time frame. So there will be a longer gestation period than a lag. Very quickly turning to the first question, Eric, if that's okay.
Yes, certainly.
Yeah. So the question is, what is the typical timeline for resolving investor-state arbitration matters? And with a risk of increased sunk costs in lengthy arbitration matters, are there specific investment agreements which are less favorable? Dealing with the first one, typical, I'd say probably 4 to 7 years would be a ballpark. It can be less, it can be more, but I'd say you're looking at, if you compare that, for example, with a SIC arbitration in Singapore, which is probably one of the fastest now, we quote a 18 to 24 month time frame for a typical commercial dispute. So I've never seen a treaty case be resolved that quickly unless it's settled. But if it's gone all the way, invariably the length of time is largely a function of how busy the relatively small group of arbitrators that are typically appointed on these matters are, and the degree to which the host state is prepared to cooperate, to play ball, to follow the process in good faith. invariably that is where there are numerous problems. And you have usually, if they don't engage external counsel, you have a team of state prosecutors or state attorneys that are dealing with it. Sometimes there's an imbalance in awareness and experience dealing with treaty cases. And so it's more difficult for the government to issue instructions, to get various different ministries to coordinate their response to cases. So that's typically why these things take, I'd say, 4 to 7 years on average. And a good kind of ballpark is to use 5 years. That's what we generally tend to do to manage investors' expectations. Are there specific IAs that are less favorable? Usually, when you talk about the investment treaties themselves, it's how broad a definition is made for a covered investor, covered investment. They are, in speaking very generally, very broadly, the problem is not so much in the wording of the investment agreement. The less favorability comes in the jurisdictions that you're dealing with. Certain jurisdictions approach their obligations to investment treaties in a different way. Yes, there are obviously if you look at some of the more, so what used to happen historically, just a quick point, there was not much negotiation that went into investment treaties. They were usually put on the table by a capital exporting company and signed by a capital importing company without much understanding of their provisions. The modern day investment treaty is actually quite a heavily negotiated document, and a balance has been struck between the extent to which a government needs to protect the investments that it's seeking to attract and the requirements for a qualifying investor. And so I would say, generally speaking, a more recently negotiated investment treaty is a more balanced work product and therefore somewhat less favorable to an investor, whereas an older investment treaty is more likely to be very pro-investor because there was no pushback from the capital importing state. Thank you.
Thank you very much. It looks like we're coming in at the end of our time today. And I just want to thank the audience on behalf of both K&L Gates and Tilleke Gibbins for joining us today. And then I would also like to specifically thank Rob and Raja on behalf of John and myself for working with us to put this webinar together and for your assistance in that, or for our cooperation in that. And with that, I again thank you all very much for joining today.